Hello, welcome to Legal Action. My name is David Siegel. Today we're going to be talking about the Illinois Marriage and Dissolution of Marriage Act, and we're going to hit a few high points and low points. Joining me once again is co-host Jesse Barrientos. Jesse, welcome to the show.
Thanks, Dave.
How you doing today?
Excellent. How about yourself?
I'm doing well. Let's talk about it. The Illinois Marriage and Dissolution of Marriage Act. That's a whole lot of words and a whole lot of letters for the divorce law in Illinois.
That's
correct?
exactly what it is. That's correct.
All right, let's jump right in. Grounds for divorce. You got to have them, right?
Well, before we even get there, let's just suggest that possibly, if you're having issues, because it's, actually, I think the statistics are 50% of all divorces, or 50% of married people get divorced. And
I think you're right.
It's not just in the worldly aspect, and by that I mean, it includes Christian marriages as well. So it's not just Christian versus non-married, it's 50%. And there's something really wrong with that. If it was as easy to get, to get divorced, or if it was easy to get married, or as hard to get married as it was to get divorced, it wouldn't be that. And I guess what I'm saying is that it's important for people to make an effort. The grass always looks greener on the other side, but I assure you, once you get to the other side, it's just going to be the same problems or different problems later on in the future. Hey, if you're with somebody, you should take the time to be able to decide those kind of things. You have an obligation, I think, unless, of course, there's certainly domestic abuse and things of that nature that are very serious and need to be addressed immediately. But, you do have an obligation to try to work those things out. Now, let's assuming that you've gone to counseling, you've done everything you could, and it's just over. And unfortunately, hey, there are many, many situations where it's just over, it's done, it's not going to happen anymore. Dave, it's not you, it's me.
Yeah, well, what's the problem? Are people getting married too quickly without knowing the person, or are they too easy to walk away when there's a minor disturbance?
Actually, I think that the few causes of divorce, and there are, I believe there are 3, right? Mm-hmm. It's money, sex, and communication. Which one do you think is at the top of the list?
Communication.
Communication, exactly right. Communication. You need to be able to communicate. People need to be able to communicate with each other so that they don't feel like I'm giving you ammunition for something else. Basically, when you get to know somebody, communication or any type of a mature relationship, and that's true whether or not if it's you're married or if it's somebody else, a friend, family, are composed of existing levels of depth and breadth of exchange. By breadth of exchange, I mean the different kinds of topics you can talk about. By depth, I mean how much you let the other person know who and what you are. So when I talk to you, Dave, and I tell you something that's important to me, I'm self-disclosing. I'm telling you something that is significant to me, and I'm taking a chance that you're not going to use that against me later to hit me, boom, below the belt and really damage me emotionally. So it takes 2 people to have a very mature relationship. So communication is important. If I don't tell you what the problems are, if I squeeze that toothpaste tube in the middle and, my wife doesn't tell me that, hey, listen, that bothers the heck out of me, and then one day it's just, hey, you know what, the heck with you, because you got to tell me, I don't know, all right? But you have to do it in a tactful and loving kind of a manner, Dave.
Yeah, what if she's telling you every 2 seconds that something's bothering her? Then you're going to say, you know what, I'm out of here.
It works both ways, I suppose.
You can overly communicate.
Well, I don't know that you can overly communicate, but again, it's important to communicate, and it's important to listen and not just hear the other person. I could hear you, I could hear sounds in the background, everything else, but if I'm truly listening to you, and that means we've all been guilty of it. I know I'm really busy, and I have too. I may be talking to my spouse and working on my laptop or looking at my...
You might be guilty of it tonight when you get home. It's been a long day, you're tired. Enough. You've taped a show.
That's true. And so, you know what? Hey, I need to give you my undivided attention because I also need you to feel like, hey, listen, I am, that you're important to me, that you are a priority.
Okay. Well, the marriage is broken down, Jesse.
It's done. So grounds for dissolution, right?
Can we just get it, or do we have to prove something?
Well, Illinois is a no-fault state. And there are many grounds.
No, it was her fault.
Well, that's what I hear all the time.
Well,
but the other side I was going to say it was his fault, right? But it's a no-fault state, and basically all that means is there's a no-fault ground, and there are fault grounds The difference between the two, let's just give you some fault grounds.
All right.
Mental and physical cruelty, abandonment, habitual drunkenness. The no fault ground is irreconcilable differences, which means that simply you can't get along. The difference is, with irreconcilable differences, there's a 2-year waiting period that you have to live separate and apart. And all but 6 months of that are waivable. Both parties can sign off on an affidavit. But it doesn't necessarily mean physically living separate and apart.
Okay, so you can be in the same house.
You can be in the same house, right?
Properly?
And in fact, a lot of times, especially in these economic times, we did another a show recently here about bankruptcy and about foreclosures and stuff like that. Where, hey, listen, people are staying. Maybe somebody's moved to the guest bedroom, or maybe they're still in the same bed, Dave, but they're no longer intimate with each other. They're just more interacting like roommates. And there's been a broken down. I've heard so many comments about people who, hey, listen, they've been married for 20 years or 15 years, but they haven't been intimate in
same bed but
18.
different sleep numbers.
Yeah, exactly. It's different sleep numbers. That's right, Dave.
It's almost like not being in the same bed.
That's true.
I'm glad you got the joke.
Yeah. Oh, folks at home did. We can't mention the provider there, but anyway, so you kind of look at that. The difference with the grounds, mental and physical cruelty, is there's no such waiting period. You can go right in and get the
Knock
divorce.
it out.
Right, exactly right.
Or at least get in the door.
Right, get in the door.
Okay. Let's talk about forms of temporary relief, because not everything happens overnight. We just said there's a starting point. But what sort of temporary relief can we seek?
Well, essentially, if you think of a divorce as an estate, so basically
A partnership.
A partnership, and here's this big pot. Now everything that we're married, and so since we've been married, we have this big pot, and everything since we're married here, generally, as a general rule, all the money that I make goes into this pot. It's marital. All the money that you make goes into this pot. It's marital. What you spend for credit or in the debts that you have during the course of marriage are marital. What I spend, is marital. The house, if it's purchased during the course of the marriage or anticipation of marriage, generally, it's going to be marital and subject to equitable distribution. Now, equitable distribution means that they're going to look at the prospective economic situations of the party and make a division. So basically, it's all about splitting up that property. So generally, a lot of times, what the living situation is that one spouse will be the provider, will be the breadwinner. And the other spouse has skipped economic opportunities in order to raise the children or anything like that, or maybe has even put her spouse through school by taking care of the kids, maybe working some job or part-time job, and now he's in a different situation, and it's the heck with you. So now, if this person leaves the house or something like that happens, and so now I don't have any money, the very first thing that happens, and we've seen that time and time again, is, okay, bank account drained or shifted or moved to something else. And I'm not just talking about, and hey, $1,500, $2,000. I'm talking about $250,000, $300,000 gone. Now there's no access to it. Now, and I'm not working because I'm taking care of the kids. So I need, and you've moved out of the house, so we still need to be able to pay the mortgage, still need to be able to keep the lights on, still need to be able to get heat, and still be able to need to buy groceries, and to do those kind of, and put gas in the car so I can take the kids to school or do those kind of things. So, we're talking about temporary support. We have temporary child support, and we have temporary maintenance, or even just a contribution, which is kind of in the nature of maintenance of the marital bills.
Okay, so the court can
marital
order
expenses, sure.
the status quo that each party can continue to contribute towards their mortgage, taxes, utilities, insurance, and things of that nature.
If both parties have, if it was just the one party, then, and the problem with that is, especially if the other party's gone, well, now what happens? Now the bills and everything are doubled, because now the person's going to have to support your family. And here, let me tell you, I'm a GL, which is a guardian ad litem and a divorce mediator in DuPage here, and I have to tell you, if they're your kids, if they're your children, you have an affirmative obligation, not a passive obligation, an affirmative obligation to take care of your kids. You also
I take care of my kids.
have an affirmative obligation to take care of your spouse if the economic situation warrants it. But as far as your kids, you know what? They're blameless in this situation, and you need to take care of them. I don't care if you think that she shouldn't get this or that or anything. You need to take care of your kids. I'm telling all of you people out there, and I'll tell you what, the judges will enforce that too. You need to take care of your kids, and if you don't, the judges are going to force you, and there are going to be severe consequences if you do not.
Yeah, depending on what county, it's stricter than others.
True.
But yeah, they all want to see the children be taken care of. Let's talk about the division of property. You talked about marital property.
Right.
It's typically all property incurred or acquired during the marriage. But that's not always divided equally, correct?
That is correct. If we're in and again, this is no just regular formula here. It depends. It's case specific, and it's judge specific, and it's county specific. So, but generally, the law is what it is, and there are certain factors that the judges and the courts look at in terms of dividing the pie, as it were. So, if we have a situation where one of the spouses makes a couple $100,000 and has a very promising career and is going to continue to climb up the corporate ladder and just going to continue to make certainly the same or more money, and we have a situation I was talking a little bit earlier where the other person, right, was a stay-at-home mom or dad and not making that kind of maybe foregone some educational or economic opportunities to be able to be home with the kids and everything else. The chances are that the court is going to award that spouse more of the marital estate. Now, it's important that, there's also non-marital property. And again, it's a general rule. Anything that was acquired before the marriage, as long as it hasn't been commingled, is non-marital. A good example would be let's say I had a house that I've had, and I've had for 10 years, and then I get married, and I don't do refinance, and it's still in my name. Well, hey, listen, it was mine before the marriage. It wasn't in anticipation of marriage. Now, little consequence, not really a bunny trail, but on the side here, the taxes that I pay for it, anything that I pay to improve it, is being paid now with marital money. So the marital estate is going to be entitled to a contribution of that money back to be able to take care of it. Let's take a more simplistic example. Let's say that I had a bank account with $100,000 in it, and I didn't commingle it, and I had it before the marriage. Well, generally, that's going to be non-marital monies. And I say all this to say that in dividing the pie, the court is going to look at your non-marital property. Because if you have $1 million, Dave, in non-marital assets, that's yours. It's not subject to equitable distribution. It's all yours. They're going to look at your marital estate and say, well, you've got $400,000 in marital estate. You already have $1 million. She has nothing. They're more than likely going to give her the lion's share of that estate. So they're entitled statutorily to be able to consider your non-marital property as well.
Okay. Well, that segues real good into my next question, because we're talking about division of property. We're also going to talk about maintenance, which is spousal support. If you have a breadwinner and someone who's not making money, the person who's not making money is going to require a certain amount of maintenance to sustain that kind of lifestyle, correct?
That's absolutely right, and they look at it in terms of sustained lifestyle that you had during the course of marriage. Let's say that, hey, again, we're typically higher earners, and you go on vacations 4 times a year, and you have parties, and you buy clothing.
So we need to continue that conduct even though we're not together anymore, because I enjoyed that kind of conduct while we were together? Is that what you're saying?
That's exactly what I'm saying.
Well, I think that's one of the 12 factors, but it is important.
It's one of the factors. But, that's what the courts are looking at. They're going to look at the duration of the marriage. They're going to look at, the standard, and they're all going to also look at your non-marital property. They're going to look at,
the disparity of income.
The disparity of income. They're going to look at the debts. They're going to look at, hey, listen, what are we going to do to make this even? Let's say that we're pretty much even and we make about the same. All right. Okay. Hey, then what's going to happen more than likely is it'll more than likely be a 50-50 kind of split. You've already worked. We're making the same. Again, nothing is so sure and certain. It's case and fact specific.
So the person has to have a need for the spousal support. The court won't award it just to make things even. If that person
right.
is self-sufficient, he or she doesn't need spousal support from the other necessarily, correct?
That's right. And if we're talking about, we talked a little earlier about temporary support in terms of paying the bills or paying child support or paying temporary maintenance. And now, okay, so I'm paying child support depending upon how many children you have and depending upon the need. It could be the statutory guidelines for one child is 20%, 2, 28%, 3, 32%, and there's a progression. And so depending upon now what I'm paying you, now when we look at the picture and we see at the end of the day, after tax cash dollars, what I'm getting and what you're getting, you know, you might have a part-time job or whatever where you take that into consideration, and we look at what I'm paying in child support too. So now that kind of makes us a little more even. And then if there's something additional that I have to pay, now child support is not taxable to the person receiving it, and it is deductible by the person paying it. It's the payor and the payee.
Okay. Let's talk about the disparity in income again. If someone is making $100,000 a year and another party is making $70,000 a year, we don't have a huge disparity, but yet there is some disparity.
And that's where the discretion of the court comes in, and that's
Okay.
where the length of the marriage, and that's where you have all these other things. That's where the debts come in, because, and again, at some point, it is a little bit subjective on the part of the court, on the part of the judge.
Will the court take into consideration the fact that one of the spouses may have decreased their salary in an effort to try and get around maintenance or to lower their child support? Will the court look at a totality, or will they just look at a snapshot of what he or she is making now?
They can average it. They can go back and average it as to what they were making last year, the year before. And there are a lot of cases, and it's very interesting that let's say I'm making $100,000 a year, and I'm ordered to pay whatever the child support is going to be or whatever the maintenance is going to be. Let's just say it's 50%. Unallocated. Unallocated means everything's lumped together.
That would be 6 kids.
Well, no, I'm talking about unallocated
you're mixing
maintenance, right, exactly.
Okay.
So there's nothing for support, and there's no specific amount for support, no specific amount for maintenance. And it's unallocated, which means that I'm able to get a deduction for it, and the person who's receiving the payment has to claim it on the taxes. What that allows somebody to do is for the payer to pay more because I'm getting a tax break. And so, it gets a lot more complicated than people may think. And then, in terms of the deductions, we add the value of that in there, so that might tweak it a little bit more. So, at the end of the day, you're still in a relatively even kind of position. But if you're in a situation where we're doing that, and I'm paying you, we said what, $100,000, and
yes.
and okay, and I'm paying 50%. Now, I'm just tired of paying you because you're lazy, you eat your bonbons. At least that's what I think. I hate you. Well, hey, we're getting divorced. That happens a lot.
You're not using the support for the right thing.
You're not using the support for the right things. You're buying clothes for yourself. The kids don't have the things that they need, and you're coming over here, and you're still asking me and wanting me to buy things for the kids and everything. Okay, so yeah, I'll fix you. All right, so I lose my job. Well, and you would think that, okay, well, I'm not longer making that, and so I don't have to pay that kind of money. Well, guess what? I got news for you folks. If the court determines that you voluntarily separated yourself from employment, then you may still be held to the same the same support obligation that you were, even though you're not making the money. Because if you voluntarily separated yourself from employment for the purpose of not having to pay the other person, or even not for the purpose, but you're voluntarily separated yourself from employment, it's your fault, then guess what? They're going to make you pay what you should have. And, it
so
does.
If you have the ability to work,
right,
you better work.
Right.
But there are certain circumstances where someone does lose a job.
That's different.
They transfer a division to Mexico or whatnot, and you have to try and find alternative employment,
right,
and you can't always get what you were making.
Right, and then what will happen is the person will file oftentimes, and that's good in terms of talking about enforcement here, will file a petition. That's in order to get anything before the court, you have to file a motion or a petition. That's how you get your issue before the court for them to consider what it is. And so if I file a motion or a petition to reduce child support because I'm not making as much as I was before, or maybe my spouse is filing a motion to increase child support because now, hey, maybe I'm making more than I was when the initial order was done. Then the court will make the determination in terms of, hey, what the facts are, and will, again, rule accordingly.
Now, those motions have to go out on notice. You have to have a financial statement attached, and they have to be done under oath, correct?
That's correct. Basically, again, it's all financial. It's a snapshot, so there's certain things that you have to produce, and that's true in all counties. Actually, they're working on doing a unified, comprehensive financial statement that's used by all of the counties, so that you don't have a different one in Will, you don't have a different one in DuPage, you don't have a different one in Cook, you don't have a different one in Kane, you don't have a different one in Kendall. And so,
they should do the same thing with the parenting class.
With the parenting class, but I mean, it is required in all counties. I mean,
it's required by state.
It's required by state law, and you have to have some form of the parenting class. But they're working on doing a unified, comprehensive financial statement, which allows the other person and everybody to know, and the judge, hey, listen, okay, this is a complete outline of what I'm making, what my bills are, what I've paid.
That's a great idea, almost like a standardized tax return.
Exactly.
Federal taxes are the same forms throughout the country.
Right. So that they can see, and so they're going to look at that, and that's how they're going to make their determinations. It's based upon presenting that evidence, that financial, and very often people will come to an agreement. I mean, it is what it is, and if you're making more money, hey, and again, as I said earlier, you have an obligation to pay your children. And if you're making less money, provided that it's not a situation where you voluntarily separated yourself and you have somebody reasonable, then hey, listen, it should be easy to kind of settle it amongst yourself. But that doesn't always happen, Dave.
Right. Well, a lot of people think that the financial obligation for children only lasts until 18 or completion of high school. But for those who practice in this area, as you do, you've got Section 5/513, which is post-high school educational expenses or expenses for a non-minor. So let's talk about that. What can the court do, and what can an individual do in terms of petitioning the court for relief?
Well, generally, your obligation for child support lasts until the child is 18 or graduates from high school, whichever is later. Now, understand that sometimes kids are in between, and while they may have turned 18, they haven't graduated because they're in that class, and so it might be another 6 months or 4 months or whatever. And so you have that obligation. Very often, your obligation to carry health insurance on them will go to their 23 years old. The other statute section that you were talking about refers to support for a really an emancipated or an adult child, which is somebody who has special needs and really can't take care of himself. And so, you can get support for that kind of child. And let's go back, and we were talking about the different percentages pursuant to the statutory guidelines. It doesn't mean that if I'm making $100 million a year that you get 20% of that $100 million a year, because the child simply doesn't need that amount of money in order for his or her needs to be met.
So it's a guideline, it's not a mandate.
It's a guideline, and you could deviate from it. You can deviate upward. For example, let's say that the child is a minor and that child does have special needs. He's going to counseling and other stuff, and so there's additional money that's required. The court can deviate upwards. They have to make a specific finding as to why they're doing it, and they can deviate downwards too.
I have a quick story about a deviation
Sure.
case. Final day of the divorce, you have to go before the judge with your client and with a prepared judgment and present the facts of the case. I was early on the call, so the courtroom was packed behind me. I mentioned deviation because this was one of the rare cases that we were going to actually deviate, and we had a reason to do it.
Downwards or upwards?
I don't remember if it was down or up. It was probably down. The judge interrupted me, said, "Counsel, have a seat." She then went on to call every other case in the courtroom that morning, called me back up when no one was in there, went ahead with my prove-up. She said, "Counsel, I apologize to you, but I didn't want you to talk about the deviation in front of a packed courthouse." In other words, she didn't want it known that she was the kind of judge that you can deviate with, because they really don't want to do that. So we suffered all morning, basically, but we got the relief that we were looking for. But the deviation, unless you're an athlete and it makes perfect sense to deviate, they don't really like to do it. Even though it's a guideline,
Right.
they don't like to deviate. They want to give the children what the percentage is.
Well, that's true, but if you're deviating downwards, all right, I mean, there's a whole bunch of reasons to be able to do that. For example, let's say in the divorce, all right, you're getting the house. Let's say the house has $100,000 of equity in it. And you know what? I'm a good guy, Dave. You know what? Here. And now we have civil unions. That's a whole other story. I'm going to give you the whole equity in the house. I don't want anything in it. It's all yours. Now, you know what? There's a reason to deviate because now you got an extra $50,000. However, in those situations, and I think some practitioners, especially the younger ones, make the mistake, there has to be some kind of a formula because, you know, you can always come back in for guideline support or substantial change circumstances. So it's got to reflect specifically what it is.
Let me mention something. Equity is fleeting. I had a case just the other day where someone bought out the other spouse's interest in a house for $150,000 based on the equity at the time. Well, you know what happened in the market?
Of course.
The equity completely dissipated to the point where the house became underwater. You can't undo that transaction. So I often recommend the property be sold and the equity split. Because if you do a buyout, you run the risk that the property could go up, it could go down. A lot of people have gotten caught in the downward motion.
You could do that, or I mean, it could be that I'm taking, you know, all of the debt. It could be that, you know, we have an account that's got, liquid funds in it. I mean, there are many, many different reasons to do that. But again, it just has to be very specific, and you want to go to somebody who's going to be able to draft it specifically and advise you of the pitfalls, just like you mentioned there.
Now, if someone has a general question, they can go to legalactiontv.com or questions@legalactiontv.com and get an answer, correct?
Yeah, we'd be happy to take those questions. Now, understand everything is facts specific, and the cases are unique. But you know, we will do our very best to be able to answer the question in a general nature. In fact, it'd be great if we had a show that just answered questions from our viewers.
Yeah, well, about annually we do that. But we can do it more if we receive more questions at questions@legalactiontv.com. Jesse, let's talk about the best interest of the child in terms of custody. Briefly, we only have a couple minutes left.
Okay. Well, that's putting me on the spot here.
Cliff notes.
Cliff notes here. In the nutshell, best interest of a child, you know, they're going to look at who is the parent that's going to be able to parent that child, who is the primary caretaker, who is the one from the child's birth that has taken the child and bathed them and changed their diapers, and who has taken them to appointments, who knows what their ages are, who goes and talks to their teachers and who works with them on their homework. Now, in these days that we have now, sometimes, you know, in dual job places or households, you know, maybe it's mom in the morning and dad in the afternoon. I mean, you know, that line is getting a little bit more blurred. However, and we don't have time to take care of it in these couple minutes, but you know, there's all type of things in terms of visitation, in terms of based upon the age of the child, how often it should happen, and you know, in order to build that relationship. But basically, you know, what's in the best interest. And again, it's not about your convenience, it's not about the party's convenience. It's about what's important for that child. I'm telling all you parents out there, hey, listen, subordinate your convenience, because you know what? At the end of the day, it doesn't matter if it's convenient for you or not. You brought these kids into this world, and it's your obligation to take care of them.
Okay. Well spoken. Thank you, Jesse.
Good day.
On behalf of Jesse Barrientos, David Siegel, signing off. We'll see you next time on Legal Action. Take care. Bye-bye.